Yes, just before we get into the case management directions which this court is going to make, my Lord Justice Cobb has got a small query about the orders that were made previously.
It's just in relation to the Section 38(6) residential assessment. Judge Scarrett's order of the 8th of April reflects the fact that the interim care plan provided for the parents to go to a residential assessment. Paragraph 3. Just letting you find that. But the court endorses an interim care plan, both parents, to move to a residential placement with a child.
My understanding, my lord, is that that is the court's plan. So it is the care plan that the court invited to be endorsed. That was not the interim care plan of the local authority, which sought separation at the outset.
Ah, okay. Well,
but
then,
having heard submissions,
right,
it was the court effectively refused the local authority's application.
Right, thank you.
And
okay.
So that's paragraph 2. Sorry, we're in the schedule.
Yes.
On
Yes.
page 4 of
in the recitals, my lord.
So paragraph 2 dismisses the local authority's application for interim separation at that stage.
Yes.
2nd of April.
Yes.
But I mean,
Effectively, the court's invitation to the local authority was to adopt an interim care plan that the court's assessment was
Right.
for residential assessment, as I understand it at that point, also being advanced by the children's guardian.
Yes, that's right.
So
That's helpful, thank
I
you.
believe it's phraseology rather than substance, if that makes sense. My
No,
lord.
that's very helpful indeed.
I'm grateful.
Thank you very much.
so where have you got to in terms of case management?
My lords, I'm most grateful for the time that's been afforded over the luncheon adjournment. My instructing solicitor immediately upon leaving court contacted the listings team in Kent, CCing the court manager about whom the court has heard so much earlier in today's proceedings. Unfortunately, at the time I stand here, no response has been received to that inquiry. However, the parties have been able to discuss proposed case management. There may be some observations down the line in terms of the timings, but in broad terms, the local authority proposes that a witness statement is directed from the unit by next Tuesday, so 7 days from today, and the parties are confident that we will be in a position to agree between ourselves parameters for that witness statement, so setting out what it is that needs to address. The local authority...
Well, you speak about a witness statement. Is that appropriate, or should it be an updated expert report?
My lord, the difficulty, it seems to me, with an updated expert report is that that is going to effectively require a significant amount of time. I imagine what will be asked for from the unit will be a period measured in weeks, rather than what we say is appropriate, which is a witness statement from the assessor, which sets out, the assessor who conducted the original assessments, which sets out their view, having had an opportunity to consider the various logs and other documents which your lordships have been referred to today.
Well, indeed, but that's a statement of expert opinion.
My lord, yes. It is.
So it may be a comparatively narrow ambit, but it's nevertheless a statement of expert opinion, not a witness statement as to fact.
My lord, I take that point entirely. If the court prefers to direct that it's an addendum report, effectively,
yes.
Then, but within 7 days, and to follow closely the parameters which we
Absolutely.
set out.
We're not contemplating anything more than an update.
I'm most grateful. I'm grateful, my lord. Thereafter, the local authority, by the 23rd of December, to provide an updating statement in relation to the local authority's position, having had an opportunity to consider the addendum report. 23rd. That, as the court will be aware, then takes us to the working day before Christmas, and there are, I know, some difficulties in terms of leave as between solicitors. However, the local authority would propose that the mother responds to the updating evidence by the 7th of January. because the mother's response is encompassing not only a response to the addendum report, but also the statement of the local authority. She will have had the addendum report for a week prior to receiving the statement of the local authority, so is able to at least start formulating a response. So that comes in by the 7th. I'm most grateful to my learned friend and the children's guardian herself for indicating that instructions could be provided in readiness for a position statement to be filed by the children's guardian by the 9th of January. And then I am rather in the hands of my learned friend on behalf of the father, who acts, of course, through the official solicitor, as to the timescales with which the official solicitor would require for the purposes of responding. However, the local authority would say that that can take no more than 7 days, with a view to the matter being listed in the week commencing the 19th of January. As your lordships may be aware, it is certainly the usual practice of the official solicitor to seek all of the evidence before the official solicitor then comments on the same. If there are any questions arising from the addendum report, those should be dealt with by way of Family Procedural Part 25.10 questions of an expert. And in the event that any party does seek to challenge or does seek to call oral evidence at that hearing from the residential unit off the back of that addendum report, then similarly an application should be made in accordance with Part 25 to be determined in advance of the rehearing. At this stage, no party is saying that the hearing should be listed on evidence, as it were, but if the need arises, then an application will need to be forthcoming.
And what's the estimate for the hearing?
My Lords, I've asked inquiries to be made for a period of 2 hours, or a minimum of 2 hours. I anticipate that finding 2 hours will be as quick as finding 3 or more, in fact, in the Kent family courts at the moment. So, but I know that my instructing solicitors will keep chasing the court to try and identify that date. And now that they have the framework, Mrs. Crowther will be able to notify the court manager of at least a window.
All right.
My Lords, at this stage, can I be of any further assistance before the court hears from other parties?
No, thank you.
Okay.
So who wants to go next? Mr. Batt?
Well, Lord, thank you. The only observation I made outside was because of the Christmas and New Year break, was the mother to respond by the 9th, which is the Friday, but understand the Oak Authority wish it to be on the Wednesday to avoid going into the following week. My only suggestion, because I haven't been able to take instructions over the lunch because the office line was closed, unfortunately, is whether or not the mother is by the 9th and the guardian perhaps on the 12th, the Monday after the weekend rather than on the Friday. But it seems a relatively small point, but it's just the time of the year, that's all, to give the chance to respond.
Well, one understands the time of year, of course, that always causes difficulty, but the problem with giving your client an extra 2 days is the knock-on effect for the subsequent steps.
I take the point, my Lord.
Yeah,
But
all right.
that's the only observation I make, thank you.
Okay.
If it were to assist, I would suggest that the father's statement, if so advised, which is the direction I'm seeking, a permissive as opposed to a mandatory one, if the guardian were able to come in on the 12th, we could come in on the 16th, and then that would still preserve the ability to list in the week commencing the 19th, if that would assist the court.
Well, that sounds helpful.
While I am on my feet, one matter we had also discussed was a deadline for any party wishing to submit an application under Part 25. You have heard, briefly touched upon in submissions, that the parents have been given an indication from more than one staff at the unit that an addendum assessment may well be indicated. That needs bottoming out outside of this courtroom, but if a Part 25 application is going to be made, then it would be helpful to have a deadline by which it should be.
Well, what would you propose?
I would say perhaps at the time of the mother's response, the 7th of January.
Yes, but
Because-
Mr. Batt is wanting to put that back to the 9th.
Yes.
And that's feasible in the light of your indication that the official solicitor can still respond by the 16th, even if the guardian goes back to the 12th.
Yes, because we can provide advice to the official solicitor based on the witness statement from the unit, as to whether or not a Part 25 application is indicated. And so we can commence that process before some of the other evidence comes in.
Right, so the deadline then on that basis for Part 25 application would be the 9th?
Yes, please.
All right. So is the Guardian content with that
Absolutely,
timetable?
my lord, yes. No further comments on behalf of the Guardian.
Very good. Well, that all sounds very sensible. Thank you very much. So could I ask Council to cooperate in drawing up a minute of order to give effect to those directions for our approval? Yes. Now, in terms of the reasons for the decision that we announced before the short adjournment, we will follow the normal practice, which I'm sure you're all familiar with, which is that a draft of the reasons judgment will be circulated in due course to counsel and solicitors whose details were supplied before the hearing. And as you know, the purpose of that exercise is for you to draw to our attention any typographical or minor factual errors, and if there are any outstanding matters, and I'll come to what those might be in a moment, for those to be dealt with hopefully by agreement, if not by written submissions. Circulation to the parties or any other person for the purposes identified in the Counsel General for Wales case will be the responsibility of the solicitors instructed. Any such circulation is for those purposes only, and as I'm sure you will know, any other publication may be a contempt of court. Now, that then leaves just the outstanding matter as to whether there are any other orders that may be sought, and whether we can deal with those now or whether they need to await receipt of our reasons. And I'm obviously thinking particularly about the question of costs. Now, you may, I can understand you might wish to see the reasons before you address that question, but on the other hand, you have had the decision today, so over to you as to whether you think we can usefully deal with that matter.
Not when I turn my back. I'm not instructed to make any applications in that regard.
Right. Any other applications?
No.
Well, that simplifies matters. Very good.
My Lords, may I just confirm that I can send, once agreed between the parties, that order to perhaps to Miss Duff for circulation to your Lordships?
Yes.
I believe that's the slightly easier. That's the email address I have available to me.
Absolutely.
Yes, that'd be fine.
That would be very convenient.
I'm most grateful.
Very good. Well, thank you all for your assistance in this matter.
All rise in table.
Right.